Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po rin, pero bakit?
All right, we are back from lunch already. Apologize if it was short. Hopefully you got a bite to eat. You got a drink. It's okay. You can bring your food in. Food is allowed. Just go ahead and come on in, take your seat. We'll just finish up whatever we're eating as we get ready to get started here. I will say we have to welcome first and foremost Sharon McDonald, who is first in chat today. First in chat comes with its privileges or penalty, depending on your outlook on life. And the first person in chat is awarded the internet. We re-gift it to someone every time we start a live stream. Sharon has won previously. She has co-won the internet and has been an assistant taking care of everything IP related. But now it's all on your shoulders, Sharon. Today is your day to shine. Hopefully you do great at it because we're all dependent on you. So Sharon, thank you very much for being first in chat, for breaking the ice, letting everyone else know the water's fine. Come on in. Thank you very much, Sharon. Wonderful to have you here. Let's see. We have everybody. It looks like everyone's filing in appropriately and behaving and everything. Come on in. Take your seat. You're doing great. Just watching the judge, watching this clip. It happened again today. The judge is apparently watching our live stream. I don't know. This isn't as, it could still be a coincidence. But Weather Watch, Thomas, my podcast partner, suggested, he put in chat, he says, Judge, scratch your head if you're listening. And I went ahead and put it up. And it does take about 15 seconds from when I say it to when the judge would hear it because of the delay of YouTube taking the feed, ingesting it, and then outputting it back. And there's a little bit of a delay there. And sure enough, so we waited. We put it up about 15 seconds later. The judge is like, yep. And he's sitting there looking at the computer, reading chat. I don't know what else it could be. Really, I don't think reasonable doubt exists. I believe the judge watches the live stream, which is just awesome. That's why I added his little sound bite with 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom. Yeah, that was fun. So we added that to the open this morning. Amazing. He's reading your comments. I'm wondering if he has a favorite of yours, out of you, as far as the comments. One of you that he's like, I really agree with this person. So it could be. One of you could be quite influential on the judge as he follows along with the court case. Now with his personal laptop on the bench. So. It is exciting. Okay, let's see. If you're playing around with HDMI cables, I'm not responsible for your actions. I'll default to Adam's service and hide. MCAT advice taken on board. Yeah, I will not mess around with cables today. The live stream is just gonna go. We probably don't have very much time left in court, so to speak. There's not a lot of things that are going to happen today. We've got jury instructions, which are important, but we're not starting the closing statements till tomorrow. So unless the judge wants to tell a lot of stories and do jury instructions for hours, it looks like we're going to probably have an early day out today. Then tomorrow we get a long lunch, and assuming the jury hasn't
address subject matter jurisdiction.
Maybe the jury will decide over lunch. Mr. Brooks, we probably should address subject matter jurisdiction, but not right now. Let's see. We do have the sound effects turned on, as you can tell. So they've been triggered already. It looks like the last one was by Tony Fortune doing the subject matter jurisdiction trigger. And the cackle by Ritz. Gotta like that. The cackle comes from the Jensen case, the Mark Jensen case. And that was the defense attorney. I forget the joke. I forget.
Taking it easy.
I forget what the joke the judge said. It might have been related to the "I'm not a camel" moment, but Let's see. It says upcoming live. It's still, I think it's a YouTube problem. Because I went and I cleared out all my upcoming lives and built a new one, and it still is showing as upcoming live. So I'm not sure. Kickback taking it easy.
Dead horse go unbeaten.
Beck, that command comes from a Knoxville County arraignment with a gentleman who was actually arrested on a charge of. Well, let's see. He was urinating
in front of the Walmart. Taking it easy.
In front of the Walmart.
Yep. And the particular judge who was handling his case was giving him recommendations, like more than I've ever seen before. And he's like, "Hey, you need to." Well, I'll let you hear. He says,
You especially want to go to court if it's bullshit charges because you get them thrown out.
and the guy's like, "Well, I can't. I can't fight it." And he's like,
Yeah, you can. By gosh, go down and fight them. By gosh, make them work for it.
So that was just, it was all out of the same hearing, this gentleman. It was hilarious. The guy had been arrested for urinating like in a bush out in front of the Walmart. And the judge was like, "Fight it. You can stick it to him. They got to prove it," type thing. It was funny. Katie Q 214, welcome to the gallery. Thank you for becoming a member. I appreciate their support. Awesome. You now have access to all the emojis as well as the seat commands. You move up to the front of the row, or the front row, I should say. Had to refresh the channel. Thought you were still at lunch. It's weird. I don't know why it's doing that. I think it might be a YouTube issue. I've heard a lot of people are saying that there's a problem with the chat, and it shows I'm not live. It still shows that I'm pending. Although, we've got 377 people here that seem to have made the jump. But for some people, it's still showing not there. Justin Walker says, good afternoon, watching from Charlotte, North Carolina. Watching while delivering with UPS. Justin, that's awesome. UPS deliveries are always impressive, making those left-hand turns, or all right-hand turns. I think this is what it is. No left-hand turns, all rights. That's for those that don't know, that is an enviable position. You can make some pretty good money delivering for UPS, and you have to work up to it. It's not an entry position. So Justin, hope you're loving it. Definitely getting more exercise than I am. I should probably trade you for a day or two and get a few more steps in. Does Rosie O'Neill have a soundbite? The evidence will show. I don't have that one. If you send something to the burner phone, I can listen to it and see if it will work for a soundbite. I'm very picky about what soundbites I use, just because I need it to be very clean. But let's see. It's YouTube. It's done that to other streams as well. I think you're right. The case has so few qualified testimonies compared to the Alex Murdaugh. Yes, zero experts. We did have a lot of professionals. We had, investigators and detectives and things like that, technicians, but no one, I can't think of a single person that was admitted as an expert in this case. And the importance of having an expert in the case is because they can speculate. They are allowed to offer testimony where they speculate based on their experience and their knowledge and their, all the, experience they have. Yes, UPS does a good job. Most start on loading docks, then work their way up. I had a family member, in-law, that worked with UPS a little bit. I think he was out at one of the airports. Judges make the best clips because no one is talking when they're talking. Yes, no one dares, especially with Judge Schroeder. He will cut you off in a heartbeat. So anyway, we had this moment, obviously, on Friday that was just hilarious. A lot of you guys were here for it, where our live stream played in court. The judge on his laptop pulled up the live stream and had the audio up, and he heard my commentary as I'm suggesting that the DA should be kicked out of the room for the duration of that witness's testimony that he was mouthing the words to. The defense attorney laughed, thought it was funny. Judge turned the volume off, and after commenting that we were now receiving comments. And now again, we've got a video making the rounds. It looks like from this morning when when Weather Watch told the judge through chat just to scratch his head if he was watching, and then promptly he did. It looks like that clip is on one tweet alone has over 13,000 views, and it's blowing up on Twitter. So that's fun. Super exciting. Glad you guys were here for it. I mean, this is you guys. I'm enjoying it with you. This is awesome. I'd like to watch Judge Clifton Newman again. Any trials with him soon? I don't know. We'll have to look. His courtroom isn't televised normally, so it has to be a high-profile case for a camera crew to want to set up in there with all the cost and everything involved that way. Yes. The mug, I just saw somebody just ordered a mug. Thank you very much for that. I'm drinking out of the pink mug today, and it's a Daryl Brooks quote. I am designing another drinking mug right now that's going to have our channel logo on it, as well as a saying on the other side. So I'm working on that right now. We hope to have that out soon. And I'm also looking for a better source. We do have hoodies out there, but the price is just ridiculous. I need to figure out how to get the price down. The problem is eBay takes like 25%, and so it has to bump the price up to cover that. So hopefully I'll get the hoodie price down, and we can get some merch available to you guys that's good quality and a good price as well. Let's see. Judge Newman, dozen eggs comment would be a great soundbite. Found a link, but I have no idea how to cut it. Send the link to my burner phone, Lisa, and I can cut it. I have all the equipment to extract audio and video and everything I need to that way. Judge Newman will be presiding over all of Murdaugh's next 99 cases. Yes, and I guess those will have some coverage, but at the same time, we've watched all those 99 cases, those financial cases. We've watched every single minute of every one of them already.
And now Murdaugh stole it.
And Alex stole it. So I'm not sure how much you would like to watch that one. I mean, just close your eyes and float back a few weeks into the Murdaugh trial. And imagine we're rehashing, yet again, all the financial crimes. And just put yourself in that space and say, is this where I want to be? I'm with whoever did Cackle, Ritz. Yeah, I probably don't want to be there, but we might go there a little bit if it's interesting. But there might be other cases. I mean, we've got Sarah Boone coming up. I want a purple mug as well. I just went through all the options, not a drama llama, and I could not find any mugs that come in purple. So we're looking at. I can get
no dead horse go unbeaten.
Thank you, Mr. Harbrutlian. I can get a tall, like an insulated tumbler in purple. I can do that. I just have to redesign stuff for that. So I'm going to get a purple one for us eventually. We'll have that. Yes, I'm working on plans for what we're going to do after this trial wraps up. I'm not quite there yet to announce, not ready to announce. I laughed so hard on Friday, I nearly had an asthma attack. That was so great. Lifetime memory there. Congrats on how well your channel's doing. Thank you, Texas Val. It's doing good because people like you are here. I appreciate you. I know there's a million places you could be. Other places you could watch similar content on the internet, and I appreciate you guys choosing to be here. It means the world to me, and I really, really do mean that. I appreciate it. Would not be the same without you here. Weather Watch, you made us famous today. Thanks for asking the judge to scratch his head at just the right time, or thanks to the judge for reading your comment and actually scratching his head. I think is what actually happened. Financial trials, please. No. I'm with you there. A judge mug. Sunshine Sarah, I'm pulling up the judge's address. I'm going to send him a free mug. Judge Schroeder, I think he deserves it. He's earned it. We've put him through the ringer a little bit. Poked some fun, had some fun at his expense, and enjoyed his this trial as well. So I will be sending him a mug, and we'll get that sent out. We'll have to carry a mug for the judge. It says it's a head scratcher. Purple is coming. It's coming. We're waiting. No, Agnes Sky. Yes, we are waiting for closing statements. Unfortunately, we're going to have to wait for a little while. The judge says he doesn't want to break up closing statements so that the state would go one day and then defense later in the afternoon, and then the next day the state would go again, because that's the order. It goes state goes first and last. They sort of divide it up. No time limit too, which is good and bad. But the state's going to put on their full,
I'm not a camel.
Closing statements, the full closing statements. Then defense does everything. They get one shot at this, and then the state gets another shot to counter anything the defense might have said. They also have the burden of proof, and then the judge charges the jury, and out they go. It's off to verdict watch. So we'll have verdict watch probably tomorrow afternoon. Jeff Jordan says, "Hey everyone, don't forget to smash the like button. RA needs more people to find this channel, even if it will make chat more chaotic." Thank you, Jeff. I appreciate that. I guess one of the benefits of being a member is that you're not, when we have to slow chat when it's really busy, just so that it's not so busy, I guess members don't get slowed down. they can chat as much as they want. That's what I heard. If that's not correct, please correct me. But that's why chat goes so fast, because we have so many members that don't have time limits on chatting. Are we on verdict watch? Not yet. Right now we're on jury instructions, and this is going to be both interesting and probably a little bit painful. I believe the judge should read these. I believe he shouldn't try to do this off the top of his head, even though he has years of experience doing this. I believe for appellate reasons that, just to be for thoroughness, the judge should read everything so that everything is done properly, and there's no chance of a problem there. TW, thank you for becoming a member yet again, getting that green courthouse by your name. Appreciate the continued support, TW. Thank you. Try this. Mug Mouse, thank you for considering supporting the channel. Yes. Let's see. VC, what were you saying? New member, where can you order merchandise? VC, I am brand new at YouTube. I'm not a professional YouTuber. I started the end of the Darrell Brooks trial, and so I honestly, I'll tell you, I don't know what I'm doing. I didn't know when I started. I didn't know I would need mods. I didn't know, this how little I knew. I didn't know anything. I didn't have an intro. I didn't have, music to go. It was sort of painful. It was rough. And so I'm learning constantly, and as people have asked for merchandise, I'm trying to move forward with that and do that. But I don't know exactly where to do it or how to do it. I haven't been to, how to be a YouTuber class. So I'm getting a lot of advice from some of you that have channels or are mods on other channels and help me out. So I need to find a better way than eBay to sell my merchandise. So that's where I am right now. I'm looking for a way to do that. I think if I ever get to like 20,000 subscribers, then YouTube becomes helpful in that area, and you can sell something direct with a link on the YouTube channel. I'm not there, so I've got to find a better way. Iron-on patch that can be sold. I like the iron-on patch idea a lot. Having had a couple gift patches from police departments and things for working with them. Will the sound bites work if I'm on my Apple phone? Baseball Dad, the sound bites work on my computer. It's literally this computer right here that's generating the sound bites, and it interacts with the chat. It uses the YouTube API. It's a program that can read the chat on YouTube, and it responds with triggers, so it plays the sound off this computer onto the chat. So yes, it will work. All the commands work no matter what device you're on. Can't wait. An RA mug is on my Mother's Day wish list. That is awesome. Not a drama llama. Love it. Let's see. DB was really one for the books with all the interruptions made. It was painful. I mean, it was a circus. It was fun. At the same time, it was not. I think you set the slow mode to a minimal time to wait to post between messages. So that's why it seems it doesn't slow down. I only slow it down when chat's going so fast that the mods are saying, please slow down chat, because it's impossible for them to moderate because it's scrolling so quickly. I want it to go slow enough that everyone gets a chance to have their message heard and read, because I think no matter who it is, even if it's a short message or a long message, member, non-member, super chat, it doesn't matter. I want to be able to see if somebody has a good comment. I want to read it before it scrolls off the screen. Can you become a member on YouTube? You can. You can click the join button on the channel on YouTube. That's how you do it. It's harder to do it on a phone, but if you use Safari, there's an option there. Thank you, Diana. I appreciate your support. Thanks for bearing with me. I realize that I'm a little rough around the edges and don't know what I'm doing, and that's just me. You get what you see. I'm trying to make it better for you guys every day. I think, how can I make the live stream better, or make it give you more value for your time, because I realize you're investing your time in me, and I don't take that lightly. Okay. And look at you now, says Carrie. Judge has a high noon thing, 9 to 12, time limit 1.5 hours apiece. I didn't hear 1.5 hours. I thought he said no time limit on the. So I realized that he says no time limit, but I have an appointment at noon. It's like a showdown, like a duel in Main Street or something. Heather says my mom makes sublimated tumblers and mugs. I might have to get some help from you, Heather. Chat had me worried today with how fast the undies were dropping when ZA started talking. Oof. Yeah, there was some crazy stuff this morning as we started going through all the clothing items, and I realized that there was something coming, that we were getting to the end, and sure enough, we went there. We started talking about his undies. Fake it till you make it. That's what I say. I've got a long time of faking it still, I think. Let's see. Burner phone not working as I'm texting from UK. My bill payer has blocked me. Okay, Lisa, use my email. Use my email. If you are overseas, please don't incur any charges to reach the burner phone. I didn't anticipate that when I started. I didn't realize that that there would be people who love this sort of content all over the United States and the world. And realizing that the burner phone is not very accommodating because of charges for phone calls overseas. I have an email for that. If you go to my YouTube page and you click the About button, you'll see my email. I read my email once a month, whether I need to or not. So if you send an email, just make sure you send me a chat in here as well, saying, hey, sent you an email type thing, take a look and remind me, because I forget to check, and I don't want to leave it sitting there for days without responding to you. I got a fan badge when I joined the Kid Rock fan club. It had a lanyard on it, and I get one each year when I renew. It looks like a press pass. I can send you a pic for consideration. I love press passes. Little Miss, I actually collect them. As a cameraman, I went to school for communications and electronic media. I worked in the press. I filmed for the police and TV shows and everything. And I collect all my lanyards. So I have you can hang them on my arm, just like lanyards and all the press passes that I've got from those. Some of them gave me incredible access. I filmed an Ultimate Fighting event, and I like boxing and stuff like that. Ultimate Fighting is pretty intense, and here I am. An Ultimate Fight is think of like an octagon boxing ring, but instead of just ropes on the sides, they've got chain link fence, and I'm on the outside of the chain link fence with my camera, and between fights I have to wipe blood off the lens. That was an experience and a half. But see, Tony Fortune says, love being here, love and happiness to you all. Thank you so much, Tony. I appreciate your continued support as well. Love the green courthouse by your name. Longtime supporter there. Thank you. The DB trial had me hooked, and then Murdaugh trial, which I know interest completely consumed me. It hooks you, and it just drew you in. There's Kerfuffle. Hey, look what's happening. We have the judge.
But anyway, has everybody received copies?
Yes.
Okay, we're going to...
A couple of preliminary matters. There was a request by the state for prisoner status as an issue, and I'm not giving that because that refers to cases where the status as a prisoner is actually an issue. For example, battery by a prisoner.
Judge, I don't think we asked for that. No, I think that could be taken out.
Done.
Everyone's like, right. We didn't ask for that.
You didn't send that?
No.
Okay. Blame shifting. All right. Any problems with the first page, which is not numbered, but first page?
Nothing on the first page.
That's the standard. Then page 2, information, not evidence. The charges.
These are jury instructions we're going over right now.
In regards to page 2, and I think the state can speak more to this, is they had proposed specific language for counts 1 and 2. The defense would have no objection to that, so I'll let the state be heard, but I know that what was included starting on page 2 was different than what the state had submitted.
You're correct.
Judge, in looking at the language for stalking, because there are so many and/or propositions, it becomes so cumbersome to read that I wonder if the court would be willing to look at our suggested proposal, because it removes all of the essentially or ones to make it more streamlined and understandable.
Why do you charge it that way? That's how the information comes to me. That's the charge against the defendant.
Because that's how it is generated in our program, and I can't speak to that. What I can speak to is, I think, the same level that I'm sure the jury feels, which is all of the or this or that. I mean, it becomes very cumbersome. So when I streamlined the proposed ones it specifically has fewer, obviously, or situations, but also it removes a lot of the potential ways someone can stalk someone else that don't apply here, which is what the pattern instructions actually call for, is to be more specific.
And we wouldn't have all of these problems had you charged it, because you recognize the problem. The problem is that you divided it in two separate instructions, even though there are two counts, but I prefer to instruct once on the crime.
Okay.
You have one for Sadie Beecham and one for Mr. Gutierrez.
Correct. So
I propose to give only one.
If the court would be willing, I have access to be able to edit it here. If you would prefer the language of where you have it as of another, and to take out specified victims' names for counts 1 and 2, I believe that then we could go with the Sadie Beecham pattern instruction, which I believe would cut down on a lot of reading for the court in terms of all sorts of additional options. So if the court's willing to do that, I will make that change here while we sit here and save us all some time.
You make it so I can't even argue with you.
Fantastic.
All right, yeah, please do that, because that the biggest problem was covering all kinds of areas that didn't need to get covered, and the second problem was doing it twice back to back. But if you cure up those problems, then I'll be delighted. So then, and in the meantime, you also had submitted and both because of some CCAP issues in copying, I didn't eliminate some of those various ways in which the crime can be committed that you spoke of before lunch. And so if you can strike off those that are inapplicable,
Will do.
yeah, that'd be great. Okay, so then let's skip ahead to
Judge, you're gonna need to give her a moment to switch those up, though.
all right.
She will not be able to
I thought she
listen.
was ambidextrous.
No, we can probably move on. Well, I'm just having to change names. So and I know Ms. Muller and I have kind of already went through some of the issues we saw, so I can rely on her to yell.
Okay, this camera's crooked.
Yeah.
Do you guys see this?
Okay.
It's driving me nuts.
In the meantime, is there any problem with the count 3 instruction?
Yes, the court has the first name of Mr. Gutierrez as Rosales. It should read Rosalio.
Well, don't blame me, that's the computer.
The computer.
Yeah,
Yeah.
you're right.
But
But
apparently the
besides
judge doesn't make any
that,
mistakes.
I had no other edits for page 6 or count 3.
Okay.
Carrie, thank you so much for becoming a member.
And
Appreciate
then
your
the
support.
fourth count?
So under the fourth count, under the law, it says, hold on, sorry, my computer is being all annoying.
Must be the
It
room.
says it's the fourth count, and then it says between the dates in the city of Kenosha, Kenosha County, Wisconsin, hit a court. So the defendant needs to be added into that.
Oh, I changed did hide. The district attorney is still using language like to wit.
No,
And-
sure,
and-
but it doesn't have a
and it's-
subject.
Yeah, you're right. It creates a problem when I change it without putting the defendants, because, yeah, you're right. So I'll put in the defendant hit a corpse with the intent to avoid, etc.
Yes, thank you. But then there were no other substantial issues with the remainder of that instruction.
Okay?
The next issue that I had come across was on page 11, Judge. The stricken testimony instruction was there for a second time. It was a repeat.
Well, I originally I thought I had taken it out because there was stricken testimony, yes. Thinking that there wasn't, I took it out, and then I noticed it was submitted, so I put it back in. So I'll strike it once.
Yes. Thank you. And then let me know when you're ready for the next one.
Okay, improper questions. Well, in evidence defined improper questions, objections.
That was all fine, Judge. And if you're
And that's where the second time the stricken comes in, okay.
correct.
Then testimony of a witness granted immunity or other concessions.
Yep.
Any problem with that?
No.
Prisoner or witness,
We're taking that
that's the
out.
one I don't propose to give.
Just put a
The
link for the
cautionary
judge scratching his head
instruction.
this morning. That's
Yes.
the Twitter
And I
link.
noticed I had put it in at the end so I wouldn't forget about it when I first was working on these.
It's got like
So that
16,000
second
views.
appearance way at the end will not be involved in the case. Evidence of other conduct. Any objection to that?
No, and I'll just
Oh, that's
note,
one, yeah.
I'll just note that that was the proposed language that the defense had provided to the court.
Good. I was able to import that.
Good.
Credibility of a child witness.
Yes. That was requested by the defense.
Any
Yep.
objection?
Dean, I see that. I
Agreed
think it's a
facts?
YouTube issue.
Any objection?
Nope.
Exhibits, any objection?
No.
Yep. No kidding.
Circumstantial,
Nope, that's fine.
no objection.
No objection.
Remarks of counsel,
Fine.
Fine.
closing arguments, weight of evidence, jurors' knowledge, and expert opinion, any objection?
No objection, Judge. What the state and myself did confer on, though, was as it relates to expert opinion, we believe 205 should be included because there were a couple of hypothetical questions that were proposed to experts during the trial.
Which experts? I missed all the experts.
So we would just ask that 205 be inserted, and the standard language of that instruction is fine.
Agreed?
Yes.
Let's see, credibility of witnesses, any objection?
Nope, it's fine.
No.
Oh, except that the very last paragraph on that page, the defendant has testified in this case, I won't give that, of course.
Yep.
Impeachment of witness by prior conviction.
So that number, it says, evidence has been received that 2 of the witnesses, the state and myself counted that there were 4 witnesses that had prior convictions. So just to change 2 to 4.
Well, actually, what I usually do, and I'm sorry I put the 2 in there, I usually say evidence has received that some of the witnesses.
I think that's fine as well, but the number 2 is
Either's fine, but 2 is just
2 is wrong.
Yeah. Defendant elects not to testify. You did request.
Correct.
Okay. The closing instruction.
Looked fine.
Well, actually, it's not. I turn the page here, and first thing I see, the President of the United States, and that's from a different trial. I
Oh, I am seeing that.
gave some instructions about
This might be
the
crazy.
freedom of the jury to do what they wanted, and not what.
Wonder what trial that was, Judge.
Yeah.
So I will give
Standard one?
either the standard or something very close to it. Then verdict submitted and unanimous verdict. Any objection?
No. And no objection there, Judge.
And then that remainder of the questionnaire, that's all out.
Yeah, and then that 275 that's at the end will just be taken out.
Yep.
I
didn't
think
have
it's a
any other
reporter.
notes. I don't know if the state did.
I did not.
Okay.
And Judge, I'm sending to your clerk right now that jury instruction for counts 1 and 2.
Very good. Thank you. Thank you.
I have an apology accepted. Just don't let it happen again.
Electronically.
Tanya, we love the lurkers here.
Well, yeah, print one too.
Appreciate you. Yeah,
Well,
very much
print
so.
the copies for
Everyone's
them,
going
too.
through something. You
So
don't
make,
know. But, I hear you. Thank
4
you.
copies.
We're sorry we can't open this.
Huh?
We found a problem with this content.
It's the same problem I had before. That's, I think that's a CCAP problem.
Jim Bobby, I think it's a YouTube issue. I'm going to do what the judge does and blame it on somebody else. Because clearly we're live. Okay. As they get this done, once it's solidified and corrected, they're going to go ahead and do jury instructions first. That should end our day.
Are you able to open it? Yeah.
No, the judge doesn't scratch his head a lot.
Just print it. We'll get it open later.
I can't print it because I can't open
Oh.
I will print it to my office. I will run and go get it.
How many signals did he do before you noticed? This is the first time we asked him to do anything. Nanny Apple, I see you there saying being a lurker. I love being a lurker. You guys are my faves. Thanks for being a supporter, Nanny Apple. Appreciate that.
Might work.
Yeah, it says live once we're in here, but the on my channel page it shows that this video is still upcoming. So you have to click on it to get in, and then it shows you that we're already have been live for 36 minutes. Matthew Harris, welcome, my friend. Hope your day is going great. Good to have you here in chat. The judge has been on the bench since the Jesse James trial. Oh, man. You emailed the eggs link. Okay, thank you, Lisa. I missed it last time you said that. Sorry about that. I will check that. If the audio is nice and clean, if it's good and clean, I might be able to use it. Sometimes, like this courtroom's hard to use audio from because I have to run a lot of filters on the sound just to clean out all the air handler noise, that hum we've been getting headaches to. Somebody just texted me, scratch your head if you see this. So there, I scratched my head. There you go. That was, is that 6 volts? Oh, it was, okay. I know who this is. Never mind.
She can't put a foreign hard drive into the state system.
Yeah, that'll help.
Dude, this.
Well, looks like you'll have to retype everything then, Judge.
Actually, if
You can scan it in, could you?
which paragraphs did you take out? Yeah, I like that idea.
To scan it in?
TW
I
just
can
gifted a
scan
membership.
it into my phone.
And Yo Mama received
I
it.
mean, is that as a PDF? I
No,
can
so
send it
I'm
to you.
having a physical copy run over, and then we can.
I see what she's saying now. She's saying maybe if, here, I got you.
But I don't know if it'll let.
Because before when I sent to PDF, it didn't work. So I'll send that to you right now as a PDF.
Okay, so the clerks and the counsel are arguing about how
What
to
a bunch
get.
of dinosaurs in here, you know? At least she knows what
Yeah, my favorite time.
she knows what she's doing.
I thought maybe if you send it in a different Word format, I'd be able to open it.
I'm going to try this.
I did not have pickles for lunch. My daughter was very proud of the fact that she had made fish sticks, which are frozen, and you just put them in the oven and cook them. She was very proud of the fact she did it all by herself, and she said, I made you fish sticks for lunch, so I ate those. She was super proud, just all grins, that she had made me lunch.
And I don't think he's going to be able to edit it. If he has.
The DA is not happy. He's doing the lip seal thing. Bunch of dinosaurs in here.
I don't know if I have that ability.
Well, even if I have a PDF, that should be fine.
Okay, I'm going to send it to you, Judge.
Except that's, let's see, that looks like the one in the pattern instructions, and that would be unedited.
Honestly, I have it, but I don't have the Word conversion.
No, I had fish sticks with vinegar, malt vinegar. My personal favorite. I know it's my family makes fun of me. I'm the only one who likes it. But being over in England, fish and vinegar, fish and chips and vinegar, they go together.
On the right hand
I am very proud of her. She's amazing.
It's going to say,
You have to purchase the
plan.
Yep.
Did it work?
I said, yeah.
No. CCAP won't purchase the plan we need to convert it.
They're struggling to get this document into the judge's computer. This is the whole discussion right here. They're talking about taking a picture on their phone, making a PDF, and importing it into the judge's computer.
Yeah, we can do the electronic version later. We've got everything set now, I think. Any other concerns with the instructions?
Thank you, CJ. Appreciate you becoming a member.
All right, let's call the jurors.
And you're going to ask them about 8:30, Judge?
I am.
8:30 in the morning. We might get an early morning tomorrow to make up for our long lunch. You're on notice right now.
Hello.
Would you come down, Blaze?
Yes.
I don't know why the camera always pans up to that every time the jury's coming in. I think it's in case somebody walks across the room. I don't think the jury walks across the room. They enter from the left and stay on the left. But it's just a cautionary thing. Apple cider vinegar is supposed to be a very healing product. I know some people recommend drinking that apple cider vinegar, the one that says like with the mother on it. I'm not sure what with the mother means, but I've had a little bit of that, and that's about all I can handle is a little bit. I could record it for him. I could make a PDF and send it to him. I just need his personal email. We'll get the documents sorted out. Fish with malt vinegar, fries with cocktail sauce. I'm huge on shrimp with cocktail sauce. I've never tried fries that way.
Bring the jury.
Bring the jury. Drink pickle juice is good for your guts. Yes, I'm not sure if spicy maple bourbon pickle juice is as good for your guts as regular pickle juice like dill, although I do like them both in small amounts.
Just to acquaint you with the schedule going forward, you're almost done. I'm gonna instruct you on the law this afternoon. It's going to take about, I'm going to say, half an hour. And then you'll be released for the day. And then I'm going to ask that you return tomorrow at 8:30. Is that convenient for everybody? And we'll hear the final arguments of the attorneys at that time. We hope to be done by noon. And have the case in your hands then. That's not a promise.
Lunchtime deliberation.
But that's the hope. Like when I told you it was going to be 2 weeks. It was a hope, and I expect a better result this time around. And I'm going to instruct you now on the principles of law which you should follow in considering your evidence and in reaching your verdict. It is your duty to follow all of the instructions, regardless of any opinion which you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved in the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions, and from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only.
Page 2.
Keep in mind that the information is nothing more than a written, formal accusation against the defendant, charging him with the commission of one or more criminal acts. You are not to consider it as evidence against him in any way, and it does not raise any inference of guilt. The information contains 4 counts of charged unlawful behavior against the defendant, and to each of these counts he is under the plea of not guilty, which is a demand that the state prove every element of each charge beyond a reasonable doubt. Counts 1 and 2 of the information charge that between the 1st of August of 2020 and the 17th of May of the same year, at the city of Kenosha in this county, the defendant intentionally engaged in a course of conduct directed at a specific person, which caused that person and which would cause a reasonable person under the same circumstances to suffer serious emotional distress or to fear bodily injury or death to herself or himself or to a member of his or her family or household, and where the defendant knew or should have known that at least one of the acts that constituted the course of conduct caused the person to suffer serious emotional distress or placed the other in a reasonable fear of bodily injury or death to himself or herself or a member of his or her family or household, and where the defendant's acts caused the other to suffer serious emotional distress or induce fear in the other of bodily injury or death to herself or himself or a member of his or her family or household. Stalking, as defined in the Criminal Code, is committed by one who intentionally engages in a course of conduct directed at a specific person, which causes that person to suffer serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household.
Judge, I apologize.
It did not come through. What I've got here didn't come through. What was sent to me?
No, the printed copy.
Remember, we gave you a printed copy that we thought the court was. Apologize, but that.
This is a printout of 1284 is what it is.
Right, but it's.
He's reading the wrong instruction.
It has the specific things we wanted in the instruction. So it has the.
That I understand. This was the parties discussed and reached an agreement on this, so this is not from one side or the other.
So we know electronically it didn't work, Judge, but we were hoping that we thought the court was going to read the printed copy we provided.
Well, actually, I see now in the latter section it remove some of the paragraphs. Okay.
This is why the attorneys are
Stalking,
following
as
along.
defined in the Criminal Code, is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to suffer serious emotional distress and that would cause a reasonable person to suffer serious emotional distress, and where the actor knew or should have known that the conduct would cause the person to suffer serious emotional distress. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the person alleged to be a victim. Course of conduct means a series of two or more acts carried out over time, however short or long, to show a continuity of purpose. Acts that you may find constitute a course of conduct are limited to 1. Maintaining a visual or physical proximity to the victim. 2nd, approaching or confronting the victim. 3rd, appearing at the victim's home or contacting the victim's neighbors. 4th, entering the property owned, leased, or occupied by the victim. 5th, photographing, videotaping, audio taping, or through any other electronic means, monitoring or recording the activities of the victim. This subdivision applies regardless of where the act occurs. And 6th, causing a person to engage in any of the acts described above. The second element is that the course of conduct would have caused a reasonable person to suffer serious emotional distress. Suffer serious emotional distress means to feel terrified, intimidated, threatened, harassed, or tormented. This does not require that the alleged victim have received treatment from a mental health professional. To determine whether this element is established, the standard is what effect the course of conduct would have had on a person of ordinary intelligence and prudence in the position of the alleged victim under the circumstances that existed at the time of the conduct. Third element is that the defendant's acts caused the alleged victim to suffer serious emotional distress. And the fourth element is that the defendant knew or should have known that at least one of the acts constituting the course of conduct would cause the alleged victim to suffer serious emotional distress. You cannot look into a person's mind to determine intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent and knowledge. If, as to the first or second count, you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, then you should find the defendant guilty on such count, either or both, or neither. If you are not so satisfied, then you must find the defendant not guilty on that count.
Lots of pages here. Man Bun doesn't get a computer, so he has to look over everyone else's shoulder.
The third count of the information charges that on or about the 17th of May of 2020, the defendant caused the death of Rosalio Gutierrez Jr. with intent to kill him. Intentional homicide of the first degree, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the fatal act. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the fatal act. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in the to aid in establishing the guilt of a defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If, as to this third count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, then you should find the defendant guilty of intentional homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. The fourth count of the information charges that between the 17th of May and the 19th of May of 2020, at the city of Kenosha in this county, the defendant hid a corpse with the intent to avoid apprehension for a crime. The Criminal Code of Wisconsin is violated by one who hides or buries a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant hid a corpse. Second, that the defendant hid a corpse with intent to avoid apprehension, prosecution, or conviction for a crime. This requires that the defendant have acted with the purpose to avoid apprehension, prosecution, or conviction for a crime. If, as to this fourth count, you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty of hiding a corpse as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty unless, in your deliberations, you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation, a doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits which have been received, whether or not they accompany you to the jury room. And third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at the trial. Disregard entirely any question to which I did not permit an answer. Do not guess at what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to the weight of that evidence. The weight of the evidence is decided by the jurors alone. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. You have heard testimony from a witness who may receive concessions from the government in exchange for his promise of cooperation.
It's Mr. Washington.
This witness, like any other witness, may be prosecuted for testifying falsely. You should consider whether receiving concessions affected the testimony and give the testimony the weight you believe it is entitled to receive. Evidence has been presented regarding other conduct of the defendant for which he is not on trial. Specifically, evidence has been presented that the defendant was involved in growing and selling marijuana and growing and using psychedelic mushrooms. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait and that he acted in conformity with that trait or character with respect to the offenses now charged against him in this case. The evidence was received on the issue of witness credibility. You may consider this evidence only for the purpose which I have described, giving to it the weight which you determine it is entitled to receive. It is not to be used to conclude that the defendant is a bad person and for that reason that he is guilty of the offenses now charged against him. The testimony of a child should be weighed in the same manner as testimony of other witnesses. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and to answer them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters varying upon credibility applied to a child witness in common with all the other witnesses. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. An exhibit becomes evidence only when it has been received by the court. Exhibits which may have been marked for identification and not received are not evidence. An exhibit once received is evidence, whether or not it accompanies you to the jury room. It is not necessary that every fact have been proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find him guilty. Remarks of the attorneys are not evidence, and if their remarks suggest certain facts which are not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the lawyers, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under my instructions. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you should take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only to facts. However, witnesses with specialized knowledge in particular fields may give opinions in those areas. In determining the weight you give to these opinions, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion.
This judge prefers to read the jury instructions before the closing arguments, and that's very common. Newman did it the other way around, I think. But Newman was different in several ways. He also chose the foreman of the jury. I think the judge just printed something off. Yes, hopeful. The courthouse icon and the green name indicates that you're a supporter of the channel. You do not have to be a supporter to participate or have your comments read or answered.
During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based, only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had for observing and for knowing the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give to the testimony of each witness such weight as you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and experience in your everyday lives. You decide for yourselves the reliability of things said to you by others, and you should do the same thing here. Evidence has been received that some of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. We are going to hear the closing remarks of the lawyers in the morning, and then I will give you about 5 more minutes of additional instruction, and then the case will be turned over to you.
There we go.
We will have 12 of you go into deliberation, and that'll be done by there's a tumbler over there on the window ledge.
It's the bingo caller.
You may recognize from your church, or not. But the names of all the jurors will be put in there, and if we need to get down to 12, then the defendant will draw out one of the names to be excused. 8:30 tomorrow. And any question, anybody? Even though the evidence is closed, you need to keep an open mind, and you've heard the arguments and those last few instructions. So please continue not discussing the case with anyone, not even fellow jurors. Don't read, watch, or listen to any account of the trial. And any questions? Have a wonderful evening, and we'll see you tomorrow.
Okay, so that's an early break for all of us. Let's see if there's any more business once the jury leaves the room. We'll hold tight here, keep the audio going. Okay, someone get the judge a glass of water. Yeah, he's been popping down some candies or some lozenges of some kind. I think his might be a little under the weather. 8:30 tomorrow is the start time, so that means 9:30 for us. So if we start at 9, we've only got half an hour, and then we'll be, I mean, we can do that, but we'll probably have to, I can't do roll call in half an hour, unfortunately. My son is working on the program right now to make roll call go faster in the mornings, and if he's able to get that done, maybe I could. But is there a live car chase, Kara? Kara, is it Kara? I think it's Kara. If there's a live car chase, we might switch to that, but let's see what we got.
Anything further today?
No.
One way or another, we need to get I have to print instructions for the jury, so we need to clear this matter up somehow.
I'm sorry, George Culture.
We're taking a try sending it to you electronically from our facility.
Yeah, when they come over, and when I can see the pattern instruction numbers on them, they're always corrupt.
I'll copy and paste it to a new Word document, removing that, and hopefully that will assist in this, but I will make efforts on that.
I think the weight of the trial coming to an end is sitting pretty heavily on Zach's shoulders right now. I think that's why you see him being a little more morose.
If you use it, somebody checked it by mistake, and I don't think they were on my screen. Okay, so I'm not put over some day or so I'll add that.
Yes, you have to.
And then, 55 for the case.
Okay, Bailiffs are coming in. We get a close-up of hair. That's funny. The camera is set to autofocus. That's why it focused on her hair. All right, so there we are. Here's what we've got. We have closing arguments tomorrow. It starts at 8:30, which is 9:30 Eastern. So we're going to do our regular 9 o'clock start time. Have a very abbreviated or short roll call, and then we're going to go straight to closing arguments. This will be fun.
Ivan Victor.
I've got Ivan on the phone here. 1 second here. Ivan, my friend, how are you doing today?
How are you, sir?
I'm doing great. Are you on the road?
What do you? Well, I'm just walking the queen. You know.
All right. The dog's out for a walk, or the dog is taking you for a walk, I think is what's happening. I've seen those videos.
You got it, sir. How are we feeling after all that?
I'm ready for it to be done. Really, I think we're ready to move on to the next phase and get the jury in their room to deliberate. Send them up the stairs one more time and see what they come up with. But
I honestly think this is going to be very quick. I think I'm going to fall into that silly category that Jim Griffin posted or posed during the Murdoch trial, where he might be guilty, but did they prove it?
Yeah.
And I hate to say it, but that's kind of where I lie in this. I'm a little weirded out by the fact that neither side seem to hone in on that speck of DNA.
Yeah.
You know what I mean?
Yeah. There was some testimony out as far as the DNA that they got a full DNA profile off of it, but you would think with that being such a crucial piece of evidence. Is the dog dragging you down the road right now?
No, I'm good. I hear you.
Okay. Sorry, sound like you fell and we're getting dragged down the road.
No, I'm good.
With that crucial piece of evidence, you thought they would have been more back and forth, at least some argument or, and we'll probably hear it in the closing statements about, how it got there or something like that. But no evidence.
Didn't it seem weird to you? Yeah, didn't it seem weird to you that even if the defense wasn't going to, would want to stay away from it, because I guess it implicates their client, but why didn't the state hone in on that? That seems strange to me.
Yeah. Ivan, it's getting really loud. I'm having a hard time hearing you. Is there a blizzard up there in Wisconsin right now?
No, we just got a lot of wind. I'm sorry about that. I hear you. Okay. I hear you loud and clear.
Okay. Awesome.
Well, why didn't they hone in on that? Why didn't they focus in on that? You know what I mean?
I don't know. It's such a crucial piece of evidence for either side. If they could plant doubt on that blood speck, take that away and look at their case. It's basically almost all circumstantial there. I mean, I'm sure they've got a slam dunk on the stalking, at least for Sadie.
Right.
But
sorry, I literally have an Amish buggy rolling past me. That's how Wisconsin rolls. We literally have Amish buggies on Main Street.
That's awesome.
At 3 o'clock in the afternoon. The last point I will make is, doesn't it seem strange to you how much effort and how much bandwidth they seem to be putting in to this jail testimony? It just seems like how they went overboard in Alex's case about the financials, how they're going overboard on trying to validate these convicts. Yeah. They're both criminals. Do you think the jury will ever care about that?
Yeah, I agree. It's bizarre. It is sort of like a distraction. I don't think that's where they needed to focus. I think the jury is probably going to throw it all out. It's just like...
Exactly. How much real estate does the DA... Every time they devote that much real estate and that much effort into it, it only plays in defense hands, in my opinion. Because it was obviously a last-base, Hail Mary, do-or-die, situation for defense to throw that last guy up there. But every time they call up people trying to refute it, they only give credence to it. To me, I don't know. What do I know? But
yep, it's crazy. Well, tomorrow we're going to have all our answers answered, hopefully, from both sides as they try to wrap it up and put a bow on it and deliver it to the jury to get the outcome they want.
I predicted it would be Wednesday. It looks like I'm a day off, but I was pretty good. But I think we will get wrapped up tomorrow. It's been quite the ride. If I had to guess, I believe jury will be out less than 3 hours. That's my prediction. Let's get a pool going.
That's pretty quick. Less than 3 is fast. I mean, that's like Darrell Brooks type speed. So
you got it.
Awesome.
All right, love you.
Hey, we'll see you, Ivan. Love you too, man. Thanks. Bye.
Bye-bye.
There's Ivan from Wisconsin. Good to have him out there. He's taking Rebel for a walk. Ivan has a YouTube channel where you can watch him take Rebel for a walk. Rebel runs that neighborhood, apparently. Little mini pin. We do have the phone line open. We have one phone line. If anybody would like to comment, now that we've reached the end of the testimony phase of the trial, we just have closing arguments, a tiny bit of jury instruction left, and then we're on to verdict watch. We did a poll, Golden Mare, about guilt and not guilty as far as how you would vote. And it came back 66% guilty, 33% not guilty. That was about where we landed on that. Rebel is a mini pincher, I believe. That's my understanding. Does this jury have an egg exchange? They should. They've been together a long time. At this point, you're almost family. I mean, come Thanksgiving time, the jury will be getting together again with all their families and just having a good old get together that way. Maybe a little cookout or something like that. Manchester Terrier. Keegan Klein, the Delphi case, wants to change his plea. Wow. Oh, puppy dog Sherpa Bone Digger, you might be starting a fight there, saying that Rebel looks like a Chihuahua. So, is this verdict watch? No, verdict watch comes tomorrow, I believe. We're going to have the closing statements with no time limit, other than the fact that the judge has a 2-hour lunch scheduled in already. But we're going to have the closing statements start tomorrow morning at 8:30 Wisconsin time, which is 9:30 Eastern time. We're going to start at 9. And then we're going to have closing. So by lunch, we should almost be at verdict watch. I guess the jury could have the decision done over the 2-hour lunch. The judge is gone and be ready to go when he gets back. That would be interesting. All right. Yes, we have the burner phone open if anybody does want to call. Other than that, what do you guys have planned for the afternoon? We have. I'm going to have. Brandy get to work on summing up the last day's video. She has a video to make, so when we're done here, she has to go to work. I can't wait to see the summation of the video. Maybe she'll put it together with the closing statements. I'm not sure, and make it wrapped into one, because we had a sort of short day today. But mini pins, miniature pinchers. Yes, that's it. Found the dog walking page, and the dog is so cute. It is. His legs just fly. It's so quick. You can watch First 30 tomorrow at faster speeds. Says, let it be summer. Cheers says, Zachariah is giving kindergarten cop Zach's dad. I can't unsee it. All right, what's Ivan's channel name? Ivan's channel is Ivan Victor, and it's right up here in chat. Let's see. Let me find one of his. Drop your name there. If you just search YouTube for Ivan Victor. I'm searching for it. Where is it? It's here somewhere. There it is. Right there. I told you Rebel ran the show. Yeah, she dragged you along, and the wind was probably from you being pulled, not the actual wind blowing past you. But Ivan Victor, that's the name. If you just search YouTube for Ivan Victor, like you see right there, you'll be able to find his channel and watch videos of him getting dragged around by his little tiny dog. Court is adjourned for the day. Yes, 8:08. It is. It's adjourned for the day. We're going to start a little early tomorrow. Wish Brandy could present to the jury too. It would make so much more sense if the jury was able to get the latest Churchwell chart for any case. I can't wait to see what Brandy does with the BK case up in Idaho as well. It's going to be fantastic. Let's see. I think that's it. We're getting hail and lightning. I think I'll turn off the computers for a few minutes. All right, KQD, thanks for checking in. I appreciate it. I guess I can go out and work on the garage now. This is weird. We've got a few hours of daylight left, and we're going to go ahead and wrap it up. I want to give a huge shout out to all the mods who have helped keep everything, I guess, copacetic. Is that a good word for today? Copacetic here in chat. And and just helped answer questions and things so that I could focus on what was happening here at the court and the audio and the technical stuff on this side. So thank you, mods. You are absolutely incredible. I deserve much less than what you give me. so thank you. Also, all the members, all the super chats, all the gifted memberships that came today. I appreciate everybody who does support the channel. That makes it possible for me to continue doing this every day. I love that we have a growing community here, and it means the world to me that you guys find this an entertaining and fun place to come and watch crimes. True crime. We don't watch crimes here unless it's a car chase, and then we'll watch crimes in progress. But that's about it. So thank you everybody for that. I'm going to try to wrap up here and go out and get some work done on the garage because it doesn't build itself. If there's a car chase, we might pick it up this afternoon since we have some time. Other than that, we'll see you guys in the morning. If you are, wherever you are, if you're listening, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and stay safe till we go live again. We'll be live 9 a.m. tomorrow morning. We do this every day. If you like what you see here, if you like the community, I would ask that you click the subscribe button. It doesn't cost anything. It's free to you, and I promise I'll never tell. So click the subscribe button, ring that bell, get notified when YouTube's working, when we go live again. But it will be tomorrow morning. You won't miss a minute of it. We'll hear all of the closing statements. Can't wait for it. It's going to be a lot of fun. It should be a little spicy. It's going to be a little fiery. There will be some raised voices. There's going to be some accusations. There's going to be some finger pointing. There might even be some name calling. We're going to get all of that tomorrow. And of course, we're going to get the judge's antics as well. I appreciate Judge Schroeder. Thank you, as always, sir, for tuning in, for liking the show, for following chat, for scratching your head when we ask you to scratch your head. All things we appreciate very much so. Judge, doing a great job. Anyway, we'll see you tomorrow. On that, we'll wrap it up. Thanks a lot. I haven't shown the ice cream case yet, Rich Buddy. I have it going in the background, but that's it. That was just auto rolled over because the video stopped. Have a fantastic day. Thanks, everybody. Appreciate you. We'll see you tomorrow. It's always good when I mess up right at the last minute. Thanks, guys. See you tomorrow.